Under the old law, there were, decades of cases that talked about the fact that the Georgia courts would disregard a choice of law provision if that law that was chosen was offensive to the public policy in Georgia. And almost uniformly that meant that in every instance the court would disregard the law of the other state and apply Georgia law. Where the Georgia courts originally said, the Georgia Court of Appeals originally said that they would not extend that doctrine was with respect to a venue selection provision. So if you had a mandatory venue provision that said that in any disputes regarding this agreement will be litigated in New York or Ohio, whatever it was, the courts would enforce that. But the decision in which the court originally made that finding, the court found that the person challenging the venue provision had not demonstrated that if the case was litigated in the other state, that the other state would apply its law and that the other state's law was repugnant to the public policy in Georgia. So interestingly, after the new statute was passed, in fact, it was actually the first case was literally the same day that the legislature passed the statute again. So May 11th of 2011, there was a case where the Georgia Court of Appeals found that the venue selection provision should be ignored because the party in that case had demonstrated that, I think, was that one Texas? No, it wasn't Texas.
Iero was the one that they were essentially overruling, right, which is New York.
But what was the law that?
I think it was, sorry?
Illinois. Okay, so it was that the Illinois courts would apply Illinois law and that Illinois law was repugnant to the public policy in Georgia. And so the court in that case upheld the trial court that had disregarded the venue selection provision. And then you've had several subsequent cases, Orson versus Carson Holdings, it's in the materials, and then a case that I had, Lapola Industries, where the Court of Appeals repeated that and said that even though the statute says that, the statute says it does not apply retroactively. So as Michael was saying, it only applies to agreements that were entered into after May 11th of 2011. And the courts had to look at, well, what public policy then applies to agreements that were signed under the old law? Has the public policy in Georgia changed? So now things like disregarding the choice of law provision, disregarding venue selection provisions, that under our new public policy, that rationale doesn't exist? Or do you apply the public policy that existed at the time the contract was signed? And so the Court of Appeals has now held several times that you apply the public policy as it existed at the time the contract was signed, which to me kind of goes against what Michael's arguing about the Fabric case, that the court, at least the Court of Appeals has indicated that it's going to continue to enforce the old common law as it had with respect to agreements that were signed before the new statute. And, I think that the Fabric case really doesn't blue pencil or modify the covenant. All the court there does is apply the rules of contract construction and finds that because in other places within the lease, the type of store that was contemplated is clearly indicated, that there's no reason to read into that provision that it relates to any store, as Michael said, that rather when reading the lease in its entirety, that provision was meant to reference only a Fabric store. So I think that you can read the Fabric case in a way that's consistent with the old common law, and that if you look at all of the other decisions that have come out from the Court of Appeals on the venue selection and on the choice of law provisions, I believe that the Georgia Court of Appeals and ultimately the Supreme Court will continue to apply the old common law just as they had before with respect to agreements that were signed before the new law went into effect.